Okay, let's go on the record on cause number DC 208643, Hume versus Five Star Global. Council, make your appearances.
Jeff Diamond for non-party Dolcefino Communications.
Your Honor, Jeff Harper here for Southfield.
Good morning, Your Honor. Jeff Tillotson, Austin Arabali, here for all of the defendants except Southfield.
Good morning, Your Honor. Julie Pettit and David Urtiago on behalf of the plaintiffs. I'll be jumping off in a minute for another hearing, but Mr. Urtiago will be here.
Okay. And Mr. Harper, I don't see you on the, maybe I'm missing you. Are you not under, oh, there it is, under G Harper, okay.
I was feeling left out for a moment.
Yeah, it's just couldn't find you. There you go. All right, let's go ahead and proceed.
So, Judge, I'm sure you've had an opportunity to view everything, so I don't want to take but a minute of your time, and then if the court's got questions, we can go from there. But I think it's relatively simple. Mr. Dolcefino, who is a 30 Emmy award-winning investigative journalist, wants to be able to record and broadcast proceedings going on in this case. We filed a motion to request permission to do so. The U.S. Supreme Court, the U.S. Supreme Court, the Texas Constitution, Texas Rules of Civil Procedure, and the Dallas local rules all give him permission to do so. So we've cited to the relevant authorities in the motion. We just thought it was appropriate procedure to bring this to the court's attention ahead of time, in case the court had any issues that they needed to address about it. I know that Southfield, who's I think the only party who's filed any objection to this, primarily contends that, well, this could be prejudicial, but it's a public proceeding. There could be confidential information that comes out during the course of hearings in the trial, and I think the court's got plenty of mechanisms to deal with that, and I'm sure the court is well familiar with procedures for how to deal with confidential information being addressed in the courtroom. So we don't really see a reason why Dolcefino Communications shouldn't be able to have access to public proceedings with camera. So that's all we're here for.
Response?
Morning, Your Honor. So obviously we filed a response, and I know, although this appears to have been set for a long time, I don't want to repeat everything that we've already raised in our prior hearing. So let me start with just a few things that we have put in there. Number one is, obviously, as you will recall, at our last hearing, after lengthy discussions, we were given permission to serve some discovery, which we have served. The response for that is not yet due, just because, thanks to the rules, once we got your order, we had to send out a notice and then wait 10 days and serve. We have filed a motion to put this off and ask the court to please hold off hearing on this until we get answers to the questions that we were left with, and the court thought that it was appropriate to obtain discovery on, to which we have not yet had. I will add to the court, as we're talking about, sort of who hired or what communications have had. The one fact that I was not aware of at our last hearing that I am aware of today, that I think is worth pointing out, is that when Mr. Dolcefino contacted my client, obviously Southfield is listed as a party here, but he did not just call Southfield and ask to randomly speak to someone. He rather dramatically called a particular member of our firm and called him on his cell phone number, which is not a listed number. That is a number that, I won't act to the court that the only person who has it is the plaintiff and the plaintiff's attorney. That's not true, obviously, but that is not a number that is out there publicly listed and available. So they knew exactly who they were calling and why they were when they contacted our client. We obviously will get some answers to that when we get their discovery responses, but we do not have that yet. So that's first. We just asked the court to hold off on. As far as the rest, Your Honor, again, that's in our previous pleading, and I don't want to re-argue what I put there. So I'll just say briefly two things to the court, which is that while I love hearing that he's a 30-time Emmy award-winning journalist, which he certainly is, and I'm not trying to insult his regional Emmys, the issue that is critically important here is that's not what he is anymore, right? He was an Emmy-winning journalist when he worked at the station that he did. He now is a for-hire person. The only reason he is doing this story is that someone has hired him to do it. The only people he does this for are lawyers or some other affected party. The stories that he writes 100% of the time come down on the side of the party that is paying him to do so. And I think that that is an issue that is, critical for us to focus on before we do this. Now, the court gave us a heads up last time as to what the court's standard rule is in these circumstances, and I know that. So I'm trying not to waste the court's time other than to point out that there's a lot of very strange issues going on here. The last argument that we put in our briefing is the issues we have to deal with the confidential papers that are out there. My point here, Your Honors, we pointed out is that we got well over.
What is the status? I saw in the paper, in the filings, that there has not been, and maybe Ms. Pettit or Mr. Artiago can address this. What is the status of the discovery? That it was pretty limited discovery, but what is the status of the discovery on this?
Your Honor did order limited discovery, and we are prepared to comply with that. However, I guess Southfield didn't like Your Honor's order, and so they sent 70-something requests for production that are so far beyond what Your Honor ordered. So for that reason, we have filed a motion for protection, and we'll respond in accordance with what Your Honor ordered, but we do not intend to respond with respect to what went well beyond what Your Honor ordered.
Can I comment on that, Judge?
Sure.
Yes, in fact, my understanding of that was it was very limited, like a couple of categories, and they did serve him with a request with 73 document categories on it. The subpoena was served, I think, Thursday, and it gives us only 5 days to respond. Obviously, we will be filing a motion for protection on that.
Mr. Harper, how did we go from 2 areas to 73?
Well, 2 things, Your Honor. One, as far as the one, we caveat as to how we're still, where we are for this. If they intend to comply to 2, if that's the way Your Honor read the thing, then we'll get those 2, and the rest we'll deal with. That's obviously been set for hearing. As far as the rest, Your Honor, I think the answer is you said we could have this. We were aware that there's still, based on the objection they've made, ambiguity as to what we mean by people involved. And so we put a lot of specifics underneath it. But Your Honor, I mean, that motion is set for hearing in August. We expect that we will get the discovery that they are not objecting to, and that may very well resolve the issue. And we may never even hear it more. If we need more, then Your Honor, we've got to, then we'll deal with their motion, which has already been set for hearing by the court on August the 8th. But again, if we get the discovery,
It makes, I guess it makes more sense to me that we hear those 2 things together. I'll be honest, this is, I've been doing this a long time. I don't think I've ever had a case, maybe had one, where we had actually the hearings that were filmed. Well, that's not true. There's probably 1 or 2 that we've had hearings that were filmed. A whole trial, I've never had a whole trial. This is kind of a brave new world where you have what exactly is a journalist. And back when these rules were adopted in 1992, I don't think anyone anticipated where we would be today when it comes to the state of journalism and how all this stuff is done. And so, and I am aware, based on some stuff I've read in the media, about some of the issues involving this journalist and vis-a-vis the judiciary. With that being said, I really do feel like before I make any final decision, I need to figure out what is the relationship here and what is this journalist, Mr. Dolcefino, I think is how you say his name. Mr. Dolcefino, is what exactly is his role here? Is he a emissary and representative of the plaintiffs, or is he an independent journalist, or something in between? I don't think I really know that, I don't think I will know that until the discovery is completed. So at this point, I'm going to go ahead and just hold this in abeyance until that decision. I did notice that there was a continuance filed on this case. What is the status of the appeal on the underlying case?
Your Honor, I think the continuance you're talking about was the one we filed. Ironically, it was to continue this hearing, which I think the court just basically did. But for whatever reason, that continuance didn't get set until August the 15th. That'll be moot, so we'll pull that down in light of what the court just said. But I don't think anyone has moved to continue the actual trial.
When is the trial set again?
Sure, Your Honor, it's set for August 23rd. And what the status is with the Court of Appeals is it seems like they were confused, even though I believe Mr. Tillotson's brief and our brief made very clear what was going on with the trial setting. The Court of Appeals, for some reason, thought the issue that was sent to them was moot, which is obviously not the case. And so Mr. Tillotson, I believe, has a brief due today to explain to them why it's not moot, even though his brief did a great job of telling them that originally. But
So in full disclosure, my coordinator got a call from a clerk over at the Court of Appeals. And maybe that's the wrong title. I don't know what the role is, but I think she was a clerk, with that question about it. Isn't this moot because it's already set on the jury docket? And we explained to him, like, part of the case is jury, part of it's non-jury. I thought that resolved it, but apparently it didn't. And so hopefully we'll be able to get this resolved by the Court of Appeals as soon as possible. So
we're filing something today with the court at their request, Your Honor, making that clear again. It
Okay.
sounds to me like they just looked and saw it was on the trial docket and called someone and said, is this on the trial docket? And they said, yes. And then they said, okay, what's the problem here then? So
why are we fighting over this?
yeah, why are we fighting? Which is a good question, I suppose. So, but we're going to clarify that today. I don't think anyone disagrees what the court has done. One issue is we were unable, maybe Ms. Pettit can help. We were unable to find a signed order on the first motion Ms. Pettit brought to remove this from the jury docket. I think the court orally granted it. We later filed a motion to reconsider that issue. We have Your Honor denying that on the record. We couldn't find an original order for Ms. Pettit. There's no doubt you granted her motion and removed us from the docket. I think that's maybe that was some of the confusion that they had. I'm not.
Is there something else I need to sign at this point to make it clear for the Court of Appeals? I'm happy to do that.
Okay, Your Honor. Let me check with Mr. Irabali and see if that might help, because there was some confusion on the court. I don't know if they were just looking to get out of having to write an opinion or not, but it might help if we have a signed order clarifying that issue.
Your Honor, when it's convenient for the court, I'd like to be heard briefly.
Sure. Ms. Pettit, what are your thoughts?
I echo what Mr. Tillotson said. I don't have anything different. An order from you, a written order might be helpful. Like I said, it was clear on the record, but let us discuss, and then we'll be in touch with you with a letter, I think, if
Well, send me a proposed order if that's helpful.
Your Honor.
It'd be helpful that if you guys, it's gotten better since you got involved, Mr. Tillotson, but it'd be great if you guys could submit an agreed as to form order. Mr. Diamond, am I saying that name? Not
Yes, Your
Diamond?
Honor. Yes, Your Honor.
How you wanted to say something else? Go ahead.
Yes, Your Honor. I mean, before the court makes a final decision regarding how to handle these hearings, I think it's important to point out a couple of things. Mr. Harper's argument, while interesting, is just factually incorrect. And to that end, it really doesn't matter what the relationship is between any of these parties. The fact is that Mr. Dolcefino and his company is a journalist. They broadcast journalistic stories. And I'm sorry, I realize my camera's fuzzy. That's not my face, it's the camera, although my face is a little fuzzy too. They're not, it's unquestionable what he does and that he broadcasts journalistic stories. And as you pointed out, the status of what does and doesn't constitute a journalist is wildly different now. You know, if you survey the cases, you find a blogger to be considered to have journalistic protections. You know, the hearing that we're going to have on the discovery that was served is going to turn completely on the fact that Mr. Dolcefino is entitled to constitutional and statutory protection from that discovery because he is a journalist. So the motion for protection that needs to be heard isn't going to shed any light on the issue of whether he is constitutionally and statutorily permitted, as well as by the Dallas court local rules, to record and broadcast these proceedings. So I understand what the court's decision is, but I think we're going to be facing that same issue when we look at these questions again in August.
But maybe I'm not following, and I just want to make sure I understand what you're saying. So is it your position that no discovery should be allowed on this issue, that there shouldn't be any ability for the Southfield to be able to discover anything about the relationship between the plaintiff and Mr. Dolcefino, and that you're going to try to resist the previously ordered discovery, or are you just talking about the additional discovery?
So it is, well, to my knowledge, the additional ordered discovery is the only discovery that has been served on Dolcefino that would compel him to respond to a subpoena. So to that end, my brief review of that discovery was that everything that they've requested is patently protected per the Texas Constitution and Texas statutory laws governing same. Now, is there a circumstance under which a journalist could have information that could be obtained through subpoena? I believe there are limited circumstances under which underlying factual information could be obtained. I haven't looked to see if any of that's requested, or if we have any responsive materials. If so, provided it was within the limited scope of the court's order. But generally speaking, that's his job, and he can't be compelled to produce and respond to any number of categories of things per the Constitution and Texas statutory laws.
Well, may I, there is one wrinkle. I don't mean to cut you off, Mr. Dumont, but the wrinkle is that the two items that Your Honor did allow discovery on were also directed in a subpoena toward plaintiff. And so we fully intend to comply. I don't believe that there's anything that gives my client any sort of privilege, and we're not seeking that. So we intend and will comply with Your Honor's order.
Yeah, this may be a moot point, because if she complies, I tend to think that will at least resolve that issue one way or the other. So, and I don't want it to the extent, and I don't think you were at the first hearing. We're not trying to order Mr. Dolcefino from, any of the substance of what he's learned. We're simply trying to figure out, is there a financial relationship between the plaintiff's counsel and the plaintiffs and Mr. Dolcefino? That's the area that we're trying to figure out.
So the court is aware.
Mhm.
Yes, media has changed. Mr. Dolcefino's model has changed with it, and he is a privately funded news organization. Now, Mr. Harper wants you to believe that that's just simply bought and paid for journalism. The simple fact is, I've been representing Wayne for a number of years now, and it's just simply false. There are a number of people who fund investigations on matters that don't have anything to do with them, or in broad categories of subjects that impact them. So even if there was funding that came, and to be honest with you, don't know, even if there was funding that came from a party in this case, it still wouldn't make any difference, because that's not the test over whether what Mr. Dolcefino is doing is journalistic.
That's a fight for another day. You may be right, you may be wrong. That's a fight for another day. So I'm not making any decisions today on that issue. I want to figure out if it turns out there is no financial relationship, that removes that issue. If there is a financial relationship, then I'm going to take that into account to the extent that I'm allowed to take it into account. And then we'll figure it out at that time. And so I'm not making any decisions at this point. Ms. Pettit has already said that she's going to comply fully with the court's order. Once she does that, whether your client does or not, I will take that into account to the extent it's relevant in making my final decision on this.
Yes, Your Honor, no problem. And given that, we'd like to make an oral request that the subpoena that was served on Thursday to Mr. Dolcefino has a return date of like Wednesday. Given what we're hearing in the hearing today, as well as the fact that Ms. Pettit's apparently her client's going to comply, we'd like the court to give us some room to not have to reply to that subpoena until following the hearing. And then secondarily, when we file our motion for protection, can we, will the court give us permission to have it set on that same August setting?
Yeah, I think that's a good idea.
So can we, and so we'll set ours at the same time, but if I, just to make sure I was clear on the court's ruling, does that mean that we also can have time to respond to the subpoena until after that hearing? And if the court finds that after that hearing, Mr.
I mean,
Dolcefino.
the law obvious is that if you file a motion to quash within 3 days, then it's going to quash it anyway. So
The other thing I would add is that I believe we cited it in our motion, but I believe our motion for protection would stay your response, Mr. Diamont, to the subpoena as well.
So that's my read on it as well, but I wanted to get clarity from the court because I didn't want to end up in a situation where the court disagreed. And
It helps. We were happy to give him more time. The only reason we had that time frame was because we're trying to get everything done, right? And we, there already had to be the 10-day. So we're happy to work with him, but obviously if he files a motion, but if he wants more time, that's fine. Like I said, we've got a hearing currently scheduled for August the 8th at 4:00 p.m. If we want to take up if he files a motion between now and August 8th.
I'd like to get it all resolved at the same time.
Makes sense to me, Judge.
we'll get ours on file and we'll set it for the same August 8th setting.
And I want to let you know, just there's a possibility, unfortunately, I may be canceling my August, nothing to do with y'all, but I may be I need to figure out my schedule exactly that day, but I may be canceling my August 8th docket. Don't take it personally. It has nothing to do with y'all. I may be canceling the whole day, but I'm trying to figure out my schedule. So that day. So there's a possibility that I may, that may get moved. Don't take anything from it other than it's just, I'm canceling the whole docket the whole day. So possibly. So anything else, guys?
Not from us, Your Honor.
Thank you, Your Honor.
I would just point out we have our motion for continuance that has just become moot on the 15th. If that's easier, Your Honor, we can just move everything to the 15th at 9:30 in the morning.
Is that August 15th?
Yes, Your Honor. I mean, we don't need to have the hearing.
Let's go ahead. Let's do that. Does that work for y'all schedule? Let's move everything. Rhonda, let's move everything on this, the motions for protection, this motion, move everything to August 15th at 9:30. Does that work okay for you, Mr. Tillotson?
Yes, Your Honor, does. We'll make it work.
Ms. Pettit,
Yes, Your Honor.
Mr. Harper?
Yes, except for there's a summary judgment hearing set for July the 15th. I don't think you're talking about that. That's a different.
No, just the motions for protection. And I'm going to vote Mr. Diamont. Is that right?
Yes, Your Honor.
Yeah. All right. Does that work for your schedule?
What time was that again on the 15th?
9:30.
Yeah, that's fine, Judge.
All right, let's just put it, just so there's a possibility that docket may get canceled. I think it'll be safer to put it on the 15th. So, all right, guys, we will see you. We'll see you at, I guess we have another hearing with you guys, on Friday?
Yes, Your Honor.
All right, we'll see you guys on Friday, and that'll be in person here at the courthouse. One of y'all ended up showing here in person, and so I feel bad about that. But remember, Monday dockets are remote, Friday dockets are in person.
Thank you, Your Honor.